Welcome to Outside Views. Today we continue our series BRITURN, the Obstacles. And this is Chapter 7, Intellectual Property Law. As we examine the possibility of the UK joining the European Union again, it's essential to remember that this would not be a simple reversal of Brexit. The UK would need to apply as a new candidate and undergo the rigorous EU accession process, adhering to all the requirements for membership. Today's focus is on Chapter 7 of the Acquis Communautaire, the Intellectual Property Law. Intellectual property, or IP law, is a cornerstone of the EU's single market. It ensures the legal protection of innovations, creations, and brands across member states, fostering a competitive and innovative economic environment. The EU's acquis on intellectual property right is extensive, covering areas such as copyright, trademarks, designs, patents, and, of course, enforcement mechanisms. For the UK, joining the EU again would mean aligning with these harmonized rules and addressing the divergence that has occurred since Brexit. And let's start with copyright and related rights. The EU's rules provide harmonized protection for various forms of creative work, including literary and artistic work, databases, and computer programs. And these rules ensure that creators and rights holders are adequately protected and fairly compensated for the use of their works across the single market. Post-Brexit, the UK retained much of the EU's copyright framework, but has also introduced some changes, such as adjustments to licensing rules and exceptions. To join the EU again, the UK would need to ensure full compliance with the EU's copyright directives, including those related to satellite broadcasting, cable retransmission, and digital platforms. In the field of industrial property rights, the EU's acquis includes harmonized rules for trademarks, designs, and patents. For trademarks, the EU has established the Community Trademark System, which allows businesses to register a trademark that is valid across all member states. Similarly, the EU's Community Design System provides uniform protection for industrial designs. The UK's withdrawal from the EU meant losing access to these systems, creating additional administrative and financial burdens for UK businesses seeking protection in the EU. Joining the EU again would require the UK to reintegrate into these systems and align its national laws with EU directives, such as the Trademark Directive and the Design Directive. Patents, particularly in specialized areas such as biotechnological inventions, pharmaceuticals, and plant protection products, are another critical component of the EU's IP framework. The EU's rules ensure that innovative products and processes are adequately protected, encouraging investment in research and development. While the UK remains a member of the European Patent Convention, which is separate from the EU, joining the EU again would require compliance with additional EU rules, including those related to supplementary protection certificates for pharmaceuticals and plant protection products. The enforcement of intellectual property rights is also a vital part of the EU's acquis. The EU's rules provide harmonized measures for the enforcement of both copyright and related rights, as well as industrial property rights. And this includes provisions for civil and criminal remedies, customs enforcement, and measures to combat counterfeiting and piracy. For the UK, aligning with these rules would involve strengthening enforcement mechanisms and enhancing cooperation with EU institutions such as the European Union Intellectual Property Office and the European Anti-Fraud Office. I like the shortcut, always OLAF. Adequate implementation mechanisms are a key requirement for this chapter, and the EU requires member states to have effective administrative and judicial systems for managing intellectual property rights and resolving disputes. For the UK, this would involve significant investments in institutions, training for staff, and the development of new systems and procedures. And this includes enhancing cooperation with EU institutions and member states to ensure the consistent application of EU IP law. One area of divergence that the UK would need to address is digital copyright. The EU's digital single market strategy introduced new rules for copyright in the digital age, including provisions for online content sharing platforms, licensing agreements, and fair remuneration for creators. Post-Brexit, the UK chose not to implement some of these rules, creating potential conflicts with EU standards. To join the EU again, the UK would need to adopt these rules and ensure that its digital copyright framework aligns with the EU's acquis. The political challenges of this chapter also cannot be underestimated. Intellectual property law is closely tied to broader debates about innovation, competition, and cultural policy. For example, aligning with EU rules on IP law could be seen as limiting the UK's ability to tailor its IP framework to its own needs and priorities. Building trust with EU partners and demonstrating a commitment to fully implementing the acquis would be critical for ensuring a smooth accession process. But how difficult would it be for the UK to complete this chapter? From a technical perspective, the UK's well-developed IP framework provides a strong foundation for alignment with the EU rules. And many of the principles and practices established during the UK's membership of the EU remain in place, making the process of harmonization, let's say, relatively straightforward. However, the political and administrative challenges are indeed significant. Joining the EU again would require not only legislative changes, but also a cultural shift towards greater integration and cooperation with EU partners. And another critical component of this chapter is the EU's focus on biotechnological inventions. These involve complex legal frameworks that ensure innovative technologies in fields such as genetics and agriculture are protected while also considering ethical concerns. And the EU has developed comprehensive rules for patents in these areas, balancing innovation and public interest. The UK would need to align its patent laws, ensuring compliance with EU standards on biotechnological inventions and related areas. Cross-border enforcement of intellectual property is another area I mentioned before, where significant effort would be required. The EU's customs regulations include measures to combat counterfeiting and piracy, which often involve cross-border cooperations. For the UK, aligning with these measures would require enhanced cooperation with EU customs authorities and the implementation of advanced tracking and monitoring systems. And building this enforcement capacity would not only align the UK with EU rules, but also improve the overall effectiveness of its IP enforcement mechanisms. Furthermore, the EU's acquis includes specific provisions for satellite broadcasting and cable retransmission. And these rules ensure that content creators and rights holders are fairly compensated for the use of their works across borders. For the UK, joining the EU again would require adopting these provisions, which may involve revisiting agreements with broadcasters and service providers to ensure compliance with EU standards. And finally, public awareness and education about intellectual property rights would be an important part of aligning with EU standards. The EU places significant emphasis on promoting understanding of IP laws among businesses, creators, and consumers. For the UK, this would involve initiatives to raise awareness about the benefits of IP protection and the importance of compliance with EU rules. Such efforts would help build public support for the changes required to align with the EU's acquis on intellectual property. So in conclusion, Chapter 7 Intellectual Property Law highlights both the opportunities and obstacles of a potential BRITURN. While the benefits of aligning with EU rules on IP law are clear, the process of harmonization would require significant political will, but also public support and administrative effort. For the UK, this chapter is not just about aligning laws. It's about rebuilding trust, addressing misconceptions about EU regulations, and demonstrating a commitment to the core values of the European Union. So thank you for joining me on this 7th step in our exploration of the obstacles to BRITURN. And if you found this analysis insightful, please like the video, please share it, and subscribe to Outside Views for more in-depth discussions on our post-Brexit politics world. And of course, let's continue the conversation in the comments below the video. What do you think about the UK's ability to align with the EU's rules on intellectual property law? I look forward to your thoughts, and as always, stay informed and see you in the next video, one of those you see right here in the end screen.